Thank you, ladies and gentlemen. Let me just bring up my PowerPoint. Good morning again, ladies and gentlemen. Congratulations again to CSA Hong Kong and Macau chapter for your launch. I think in a way the organizer knows me very well because he I always overrun, and that's why he's put me in between you and lunch. But I think they've got the plan because I noticed that they've allocated an hour and 40 minutes for lunch, and you don't really need that long for lunch, do you? Anyway, I will stop when I'm feeling hungry. All right, going back to the Privacy Commissioner's Office, basically we're the independent law enforcement agency in Hong Kong kind of policing the privacy ordinance. Now, normally, the Privacy Commissioner doesn't have a view on a piece of technology or a piece of technology product. But why do we have a pretty strong views on cloud computing? That's basically because, well, as I said before, the Commission doesn't have a review on a piece of technology because we believe that there's no such thing as a good piece of technology or a bad piece of technology. There's only good use of technology or bad use of technology. That's very important. And so when it comes to cloud computing, it's really how you use it that matters. Now, before I go into the details, allow me to indulge myself into going into an introduction of the privacy ordinance. I think it's important, those who of you have heard me talking know that I'm a top-down guy. I always talk about the main thing first. Once you've got your priority right, then you know why you're doing the rest, as it were. So a quick appraisal of the Hong Kong privacy ordinance, as Maverick was talking about. We basically, the law is based on 6 data protection principles, which are very important. Now, that governs, as it were, the collection, the storage, the use, the processing, or the retention and destruction of personal data. Now, as IT professionals, we always talk about or we concentrate on the IT system part. But when it comes to personal data protection, what's most important is the data. Therefore, we must look at the data flow, right from the beginning, the creation of data, all the way to determination, the erasure of data. IT system may take part or may have a part to play right from the beginning to the end, or sometimes it's only in the middle. However, as business that looks after the collection or use of personal data, we must be careful and know that we have to look at not just the IT system, but beyond. Now, the first data protection principle is about the collection of personal data. Basically, it's a concept of informed consent. Now, some explanation of terminology. Data subjects are the individuals like you and me who may have to surrender our personal data to data users who are the organization to collect personal data. Now, as a data user, before you collect personal data from an individual, you must inform them clearly what kind of information you're collecting, why you're collecting them, how long you're retaining the data, who are you going to transfer it to in order to process them, all the rest. And the collection must be fair and not excessive, all the rest. Okay, the majority part of that would be business rules, as it were, that may not have a direct relationship with the use of cloud computing. However, the second data principle about accuracy and retention, once you collect the personal data, the data user have the responsibility to ensure the accuracy of the personal data before they can use the personal data. And they also must have a retention policy because you collect personal data for a purpose. Those purposes may expire, as it were, at some stage of time. And once those purposes are no longer valid, then you are not really allowed to keep those data anymore. So during the collection or prior to the collection of personal data, you must have retention policy in order to know how long you could keep those data. Now, if you're engaging cloud computing, then obviously the erasure part would have a contribution to the management of personal data, as it were, which I'll go into detail later on. The third part is about the use. Basically, what it says is when you collect personal data, you would have told the data subjects why you're collecting them, the certain purposes. Now, if you want to use collect the personal data for a purpose that you have not told the data subject before, then basically if there are no relationship between all these users, then you must obtain prescribed consent from data subjects. So that's because you're changing the use of personal data. So if you were porting or transferring collected personal data to a cloud service provider, you have to make sure that the cloud service provider are not using the personal data for any other purpose apart from those purposes that you told the data subjects. And also we need to be careful because during the use of cloud services, the cloud provider may be collecting personal data as it goes along as well. They may have collected the certain usage pattern of data subjects. So that personal data that's been collected, what kind of use the cloud service provider may use them for, will need to be studied. Data protection number 4 is about security. Once you collect the personal data, you have the duty as data user to protect them. Obviously, that's the main point of our talk later. Data protection number 5, data protection principle number 5 is about transparency. Now, even though you've got all these practices and policies about the collection, the retention, the erasure, the use, the security, if you don't make them known to the data subjects or internal staff, or in this particular case, your outsourcers, the cloud service providers, then nobody would be able to follow them. And gap may therefore exist. And that's why transparency of your policies and practices is very important. Data protection principle 6 is the last one, which is about the rights of individuals. Basically, what it says is, as data users, after you've collected personal data, you own a duty, as it were, to data subjects that you should tell them upon request what kind of personal data you've collected from them, and give them a copy of the personal data so that they could check it out. And if in the case that those personal data were inaccurate, they have the right to request for a correction of those personal data. So this is a quick appraisal of the 6 data protection principles. Some of those are business projects, some of those are related to security of personal data, which would be relevant to the use of cloud service providers or cloud service. Okay, before I go into the details, I want to highlight 2 main bottom lines. The first one is that data user, i.e. organization that collects personal data, they are ultimately responsible for the protection of the personal data collected. Outsourcing the data processing processes, as it were, to any outsourcers or to the cloud service provider doesn't mean you can outsource the legal liability. At the end of the day, those who collect personal data are fully liable under the law. So that's the bottom line, very important message that we all must remember and know. Okay, there are some characteristics of cloud that I want to highlight. Obviously, due to the limitation of time, I'm only talking about certain characteristics of cloud that we, from the Privacy Commission's point of view, are of some concerns. There will be all other more generic type of concerns the one you have to look after when you collect personal data, when you use IT systems to process personal data, when you outsource personal data to other people. But let's just concentrate on 3 points that we feel perhaps are very important that may create distrust, as it were, in our case. First one is the rapid transport data flow. That's one of the characteristics of cloud service for obvious reasons. The second one is I would suspect that possibly a lot of cloud service provider would have to rely on a lot of rapidly formed or loosely connected contractors in order to deliver their so-called scalable, elastic services. Last but not least, a lot of cloud service provider would only offer standardized contracts, Kit 1, Kit 2, Kit 3, as it were. Are they some of the concerns? Let's look into them. The first one is about transporter data flow. Now, a lot of data protection law will have a transporter data transporter restrictions on whether a data user can transport, collect the personal data out of their own jurisdiction. Now, in the case of Hong Kong, we call it Section 33 of the Personal Data Privacy Ordinance. That's not ineffective at the moment. So as far as the law is concerned, there's no restriction on the transfer of personal data collected in Hong Kong to other jurisdictions. I understand there might be audience or friends from Macau. That's not the case in Macau. In Macau, because they use following the EU regime, as it were, there are restrictions under the laws as to whether they can transfer collected personal data to other jurisdictions. So that's very important. Now, does it mean, okay, the law is silent, or the law allows the transfer of personal data to other jurisdiction? A data user can do it. It really depends on the general expectation or the interaction between this data user with their data subjects. For example, if you were a Hong Kong resident, a Hong Kong data subjects, you surrendered your personal data to a Hong Kong data user. Is it a reasonable expectation that you would expect the personal data that you surrendered to a Hong Kong data user is subject to a similar protection under the Hong Kong law? So if a data user had not told their data subject that they're going to transfer their personal data to other jurisdiction, then there might be a problem. So as a data user, they will have to think about that very carefully. Even though they figure out that they are allowed under law, or they have told their data subject that they could transfer the data outside of a particular jurisdiction, can they then the next question they will probably have to ask themselves is, where can I transfer those data to? For example, if you were transferring data to a jurisdiction that does not have any personal data protection law in existence, then how are you going to meet your obligation, as it were, to your to your data subject, to your customers when you do that? So data user will have to answer that question or think about that. Because at the end of the day, as my bottom line says, data user will still be fully liable, responsible under the local law. So in that case, if you were a cloud service provider that would have data center around the world, would you be able to tell your customers, the data users, where their data is going to reside from time to time, as it were? I know some of the algorithm, by the time you figure out where the data is, data may have shifted to other locations. So how you could deal with that? Because the thing is, you have to not only to tell your customers, the data users, where their data is going to be. From their perspective, they would probably want to limit the locations of where their personal data is going to reside. Now, can you support them? Can you give them a choice to say that, okay, I've got data center around the world, these are the 50 data centers. I can, if you wanted to, limit your personal data to certain jurisdictions. Obviously, the data user will have to decide whether those jurisdictions offer the comparable protection on their personal data. So that would be one thing that cloud service provider may have to think about. And we are encouraging data user, organizations to ask these questions. This is very important. As EU, in the case of EU, they've always asked that questions, and cloud service, in order to exist in EU, will have to offer that kind of service, really. This second thing about, or third thing rather, about rapid transport data flow is there are certain jurisdictions that their local law enforcement agents can access personal data stored in their locations without a due process, without warrant. Is this some kind of arrangement that you want to entertain, as it were? Have you told if you were a data user, have you told your your customer, your data subjects, that this may happen? This will be something that you have to think about, really. Second thing is about, or second characteristic about cloud service is that I suspect there are lots of loosely connected or rapid outsourcing arrangement in order to achieve the elasticity of cloud. Now, if that were the case, as a cloud service provider, would you use a second-level contractor or even a third-level contractor to deliver your service? If that were the case, how could you ensure the standard that you promise or the contractual terms that you've promised to your data user, to your customers, can be met by all these second and third level contractors. Bear in mind, we're talking about building trust. My word is not a very good way of telling people to trust me. You have to provide evidence to show that you can, whatever commitment you have to your customers are being transferred to second and even third level contractors. Now, if you only have control over your second level contractor, how would you make sure that your second level contractor has control over the third level of contractors? That will be something that you have to, as cloud service provider, you probably have to think about. Because at the end of the day, your customers will have to think about if you as a cloud service provider engaging all these multi-level of contractors, do they have a direct contractual relationship with these people? What if there's something wrong with these second level or third level contractors? They have sanctions against these people? If they don't, then obviously there's a concern. So you would, if you were a cloud service provider and you're offering cloud service with the support of multi-layer contractors, you will have to think about how to crystallize those commitments together with it. Another thing about the rapid or loose outsourcing arrangement is about who is going to, those people who are going to operate on this personal data, are they subject to any kind of local data protection laws? If they were from a location that are without personal data protection law, that probably means they do not have the concept of protecting personal data. They may think that using, having secondary use or using personal data that you've given them for other purposes is okay. So you have to make sure that, how could you make sure that people who have the right to operate on the personal data are subject to local regulations. Again, as a customers, if they do not have a direct contractual relationship with these subcontractors, maybe another thing that they could rely on is whether these people are subject to their local laws. If they were, then perhaps they would be feeling safer of handing over their personal data to these subcontractors. And also, these contractors brought up to date with personal data protection trainings. Do you give them adequate trainings? That's also another very important questions that you want to ask. Third thing is about the standardized contract. Again, a lot of service provider, cloud service provider, seem to offer standard contracts or standard offering for that matter. If that's the case, then we, as customers, as potential customers, they would probably have to ask the question, outsourcing, there may be many reasons of outsourcing data processing, but one, certainly to lower the security arrangement is certainly not one of the reasons to do that. They may not be able to meet their requirement on security, and therefore they outsource the operation to other people, believing that they could achieve that security level. So outsourcing operation, one of the main criteria or requirements that the data user must not lower their security specification or requirement. If that's the case, and as a cloud service provider, you're offering standard contract or standard offerings, and if those standard offering or standard contracts does not meet their security requirements, what will happen? Are you ready? Are you prepared to customize your contract or customize your service to meet those security requirements? That's very important. As data users, they would really have to ask that question. What if there's a gap? They could not possibly accept the gap, because if that's the case, then that means they can lower the security requirement, even if they were operating those data within their premises as well, or themselves. So that's very important, whether you can offer customization to meet their security standards. Even if you can customize your service as a cloud service provider, how could you make sure that you can demonstrate to your customers that you can meet those variants, as it were? Can you provide independent audit? Would you allow your customers to come in and carry out audit? That's very important. But that could be a problem as well, because if the data was shifting from one data center to another, how would you allow the auditors to come in and test and check out those data centers when you don't even know, or the number of data centers is pretty wide. So you need to think about what kind of report or what kind of audit you can offer to demonstrate the compliance of the contractual relationship or terms between you and customers. And if you do offer reports, please make sure that they are of real value and relevance. I think we talk about various auditing report like the SAS 70 and so on and so forth. We all know that SAS 70 is basically an auditing standard rather than a security standard. So when, as a cloud service provider, if you offer a SAS 70 report, make sure you are also offering the security standard on which the SAS report is based on. Otherwise, people would be able to. Otherwise, people may feel that they're being misled on that as well. Another thing is very important is about data breach management and notification. The president of Hong Kong Computer Society, Stephen Lau, once said that data breach is no longer an if problem or an if question, but a when question. Now that almost virtually all information or personal data being collected are in some kind of information system, the prospect of breach is pretty high. So if you were it's very important that if you are handling personal data in your own premises by yourself, to have a data breach management and notification system. It's even more important if you are outsourcing it, because you're, in a way, losing some of the controls. So as a cloud service provider, can you commit to a data breach management and notification system to meet the need of the data user? That's very important. And if you have engaged multi-level of subcontractors, how would you, through this kind of relationship, maintain that commitment to your customer, to your person, to the data user? That's very important, because your contractors may have many contracts with many other principals, as we would say. So they have their own worries and commitments to meet. How would you, through a pretty complex arrangement, know how to or maintain those standards? That's very important. Also, data breach management is not just an IT issue, it's really a business reputational issue. There has been a lot of study or talk about the 9/11 bombing or the 9/11 disaster, or in the 90s, the IRA bombing in London, in the city of London, whereby people were seeing the recoverability of business. They were saying that, I forgot all the figures, a business, if they, after this kind of disaster, if they do not recover their business operation within so many months, chances are that within so many years they will go bust. This is probably because of how they managed to recover their reputation, being one of the consideration, and the operations. Now, if we subscribe to that belief or that notion, then maybe we could transcribe that, as it were, into the data breach situation. So if, as a data user, they suffer a massive data breach incident, then, and if they do not have a formal and proper data breach management notification in place, people may lose confidence to them, and they may then lose their business and go off business. One of the recent survey by Unisys on data protection was that I think there were 80% of the respondent, general public consumer, was saying that if a company that they use suffer a data breach, a massive data breach, then 80% of the people would seriously think of switching their provider or the supplier, as it were. So people are very concerned and more concerned about data breach or security of their personal data. So having a proper data breach management and notification system is very important. Limitation on use of data, which I talk about in Data Protection Principle 3, you probably remember. The use of personal data must not outside of the original purpose that you've told data subject when you collect them. So when you, now that you've transferred or Either you transferred personal data to a cloud service provider. How would you, if you were a customer, ensure that the cloud service provider does not use the personal data for their own use, for a additional use that is outside of your original purposes? That's very important. And also, as I said before, during the usage of the cloud service, cloud provider may be collecting their own data as well, which are classified as personal data. How would you deal with that situation? Are customers of the general public or the user, the data subject know about that interaction? That's very important. Again, if you have multi-level of contractor, how would you ensure that they also respect the use of this personal data? And how would you demonstrate, if you were a cloud service provider, to your customer that you can meet those criteria or expectation? I think last but not least, if things doesn't work out, what happened? Would you offer a proper, graceful exit plan to your customers if you were a cloud service provider? What if they want to terminate contract, or what if the contract is terminated? Do you have a proper way of showing them that you can, or you have, returned all the data to them, and that there's no remnants, as it were, of the data lying around somewhere because of your redundant algorithm or your backup tapes and what have you? So that's very important. And also, if you were a service if you were offering cloud as an application as a service, then, for example, an email system, when a user clicked the delete button, have you actually deleted the message, or is it floating somewhere again in the system that could be retrieved if you want to? So again, those are the steps and assurance that you can give to your customer. And also, how would you demonstrate to them that you are meeting all these requirements or commitment? That's very important as well. I think that was the three main concerns that I want to share. Obviously, if you study them, there will be a lot more nitty-gritty details that you think about. But let me end my talk with the three characteristics that may create distrust to you. Again, rapid data transfer, rapid transport data flow, possibly rapid and loose outsourcing arrangement, and standardized contract. Those could be three main areas that if you were a cloud service provider want to address. If you were a potential customer of cloud service, you may want to keep asking your cloud service provider how are they going to resolve those issues. Okay, I'm on time. Thank you very much.
Thank you, Henry. As already, I think on the notes, we will have a panel discussion in the last part of